No worries. We are parked here till. I've got my colleagues. I'll also ask them to show of hands. Arjun, Maha, Komal. They are from the trademarks and the patents team, and also contracts. But we will talk about our capabilities later. More importantly, we need to understand the subject matter. I need volunteers as and when. So this is going to be an interactive session. It's not going to be a monologue. It's going to be a dialogue and a conversational one. So it's better for you to understand. There are a lot of pictures, very less of gyan. Lawyers usually throw up a lot of words. You are colleagues with her. So you covered. Super. So anyone wants to very quickly volunteer. This is not an assessment. We are not getting away awards or ranks or marks. But anyone wants to know or guess what is IP or intellectual property or intangible asset? Very quickly. Anyone? Fast. Fast. No? Yes, sir. So the long list is yes, patents, copyright, design, trademarks, absolutely. So long story short, whatever business you are in, most of the assets are not touchable, not tangible. You can't see them, you can't feel them, whether it is technology, whether it is innovation, invention, brand, design. So all of these are collectively called intellectual property because they are properties created by your intellectual prowess. So something which you innovate, something you create, something which is not touchable. There might be a water bottle, but it might have about 4 or 5 different intellectual properties, right? So the way it looks is what is a design. I have slides on it, but I'll show you. There is a word written here, repute, that's a brand. The way in which the bottle is made or way in which the osmosis is done to make the water inside it might be the technology or the innovation, which might be the patent. So there are same product, multiple IP assets or IP intangible assets around it. So why do you need intellectual property? If you are, most of you are startups, most of you are in your early stage of incubation or in your journey process. Some of you might have your second or third outing already, if you are already a veteran or a second or a third business you are setting up. But the valuation of a company in modern times 2024 is no longer only on factory, raw material, finished products. It is on what is the brand value, how is the company valuation being done. It is on future revenues. That is also a possibility. You don't know what it is, but future revenues are based on your capability to stand out from the crowd. Otherwise, why would a customer leave others and come to you? Your service is better, a product is better, or innovation is better. You are solving a problem better than others, therefore they have come to you. So if your problem solving ability is unique, you need to protect that problem solving ability, right? So having said that, very broad based, we have about 80-90 slides. Even if I have to run it through for a minute or two, we have about 80-90 minutes together. Please feel free to put up your hands, stop me, ask us any question, anything. As I said, innovation in India is absolutely important in the recent past, given that our recent governments are asking for ease in business, ease of doing business is going up, R&D centers are coming, GCCs are coming, our own innovations at institutions like IIT are going up. For the first time in the history of Indian patents, Indian innovators, Indian inventors are the highest filers than the foreign inventors. So a round of applause to all of you. Yeah. Please understand that Indian innovators are first time in the last 3-4 years have surpassed the number of foreign innovators filing in India. So you need to understand that India is going up the innovation levels. and that is called the Global Innovation Index. We were at 120, 130 plus, but we are coming to 40 right now. So very easy pick. Let's start with the first intellectual property, which is called the trademarks. In our world, we call it, your world, you call it the brands, or the marketing world, you call it as a brand. In our world, you call it as a trademark. So think of any supermarket. This is a physical supermarket. There can be an e-commerce supermarket, or there can be a market which is not physical, but you know that there are competitors. Whether it is lithium cell, there are about 100 makers of it. There might be Excite, there might be Amaron, there might be Sun Mobility. There are so many different marketplaces. So the name which you choose is very, very critical. That name will be your calling. That is called a trademark. But the trademark is not just the word. It can be a different set of factors and integers. So it can be from far, you can say, oh, I know this product. I mean, you can't see, it's a bit smudgy right now. So basically the brand, which is the word, which is the shape, which is the color, can be a differentiator in a crowded market. So if you are in the industry of cleaning your teeth, you have how many brands? 20, 30? If I ask around, not all of you are going to be using Colgate. There will be Close-Up, Pepsodent, names are many. Or if you have phones, then you have physical phone which is Samsung, or a TV which is Samsung, or a fridge which is Samsung. Even in your mobility, you have Uber or Ola, you have Red Taxi. So it can be a brand for a product, or it can be a brand for a service. Someone said software as a service. You're not selling a product. You're putting your product up in the cloud. Others are taking your software only as a service on subscription. Still you need a brand. You can't be a Zoho. You need a brand because Zoho has become a bigger brand right now. You can't have some similar sounding names as well. Or the same brand can both be a product and a service. I buy a car, I buy a bike. If Ola is selling me a bike, or which is the other, Ather is selling me a bike, I need to go back and get it serviced. So not only they are selling the product, but they have a service of the product. So they are selling a service as well. So the service station will also be a brand. And there can be two companies coming together in co-branding also. Hero and Honda have split. Maruti and Suzuki are still together. Tata and AIG are still together. So there can be hybrid marks also of two companies. So when there is a collaboration, you can collaborate and have a hybrid trademark as well. Similarly, you have semi-government or government-owned brands, but they are brands nevertheless, right? So Amul might be owned by Gujarat Milk Federation. All of us know for about 70 years it's been around, but it is not a private entity. It is a cooperative run by the Gujarat Milk owners. This is not a brand in the technical commercial sense, but it is a certification mark. How many of you know what is ISI or an UG mark? So there are certain standards set by the government. Only if you are capable of ticking all the qualities given by that standard will you be using this. An interesting thought for all of you. What is Wi-Fi? Wireless fidelity. Do you know it's a brand? All of us think it's a generic word, right? Like Xerox, done to death. But when you have time, write down, go look up. Wireless fidelity is a consortium of all the phone owners in the world. They came together and agreed on a technology which is called wireless fidelity, and that became a certification of the technology which they commonly use. So we'll talk about common technology patent pooling later. But this is a very easy guess. We always use this example. All of us know what that brand is. Is it written on it? Okay. So That's because you don't need a written note for identifying the source. So if the shape becomes so popular, you don't need it as a written name. So please understand, you have so many varieties. Some of them are words, some of them are colors, some of them are color combinations, some of them are only shape, or some of them are one color in the underbelly of a shoe. That's Christian Louboutin, a French shoemaker. Or it can be a music also. Or it can be a smell of a ball. I mean, we can keep going on and on. So, I mean, the list is many. I'm going to skip this because I promised you I'm not going to read out, I'm not going to have words. It's better remembered. One important thing is, please understand these two symbols, leave alone those words. You can use this symbol only if it is registered, as in the Indian Trademark Office gives you a certificate. If you use it before the certificate comes, it's illegal. You will be fined for it, but that fine also has now come down. It's not penalized or it's not a criminal offense anymore. So prefer to use a TM so that you know that it's my trademark. You tell the world that it's my trademark, please don't copy it. When you've applied it and then it gets a registration, use the R. So I can skip it, but for the sake of being very democratic, data is democracy in this country, it's very democratic. Please note this down. You can do the searches on your own, whether the brands which you want to launch, but there are persons like us or my colleagues who are very, very experienced in searching for trademarks. So you can do a Google search or a search on a general internet, but these are the place where you can go search for a trademark as well. Whether your brand is available, but you will have to search for Boolean, whether it is look-alike, sound-alike, and then whether it is in the same category of product or services. So you need to know the classification. So there are methodologies you do the search, but broadly we just wanted to know that under this broad order is all of these. So you will have trademarks, you will have patents, all of them are online these days. All data has been democratized by the Indian IP office, whether it's patent, design, copyright, trademarks, everything is available. It's free. If someone says that data is chargeable, please go back and correct them. So that's how you do the search, but we can skip all these very basic. One thing you need to know, like say I use the word Zoho, it's not yet entered into this list, but in this list are about 60 or 70 different brands. That brand cannot be, those brands which are listed as well-known marks cannot be used for any product, any service, right? It may not be applicable to Apple yet. Unfortunately, Apple is a well-known mark, but if I want to use Apple for Apple, of course, I am free to use it. If I want to use Apple for my dhoti brand, I can use it. Possibly not the same half-bitten Apple logo, right? So we need to be a bit careful when you launch a brand. You need to ensure that you are not using a third party's brand which is already ahead of you and used by some third parties. Prohibited marks are those which are in the chemical industry, sir, as in chemistry as well. And there is a list of marks under the National Emblems Act, like name of Vivekananda, President of India, Republic of India, anything which is nationalized. So they have a list there which is a list of prohibited marks. Like WHO, World Health Organization, UNICEF, UN, United Nations. Those are the names which you cannot, UN or UNICEF short form or the long form. Olympics, exactly. So that's the process. I'm not going to trouble you through the process of this, but I can show you that. Does this work? No. So I'll have to go here and show. So when you file an application, you get a number. This would be the date of filing the application. This will be the applicant name, which lawyer you used, since which date you launched the brand, what are the products or services you are using it for, and then it gets into a journal So you see that we applied it on April. In 2 months' time, it goes into the journal. This is the journal date. That will be open for 4 months. If any third party comes and says, oh, this mark is very close to mine, within 4 months they have to object. If no one objects, you will get a registration. So that's what we showed you here. There is an application, examination, advertisement is in the journal. If no one opposes, it gets a registration that's valid for 10 years. If it is opposed, then it gets maybe rejected. If opposition is rejected, then it goes here. So all the records are electronic. So there is no physical records anymore. The certificates are also electronic. This comes electronically signed and electronically generated. There is no physical courier which comes to anyone anymore. So all the IPs are electronically generated. That I've just explained to you when to use trademark and when to not use R. Right? So Madrid filing, some of you, I had a chat just before here. You might have aspirations to go to multiple countries, especially if you are in the tech world. You might have most of your business or customers in the Americas, Europe or Australia or Japan, Korea, not just in India, or possibly future markets like Africa. You need to understand that brands are territorial. IP is territorial. So if someone says, I have a global brand, I have a global patent, it cannot be. You need to pick which country you want to protect your brand or patent in. You need to file your patents or trademarks nationally specifically. There is a pipeline through which you can file. That is this pipeline for trademarks called Madrid. And for patents, it is called PCT route. So some of you who have already filed patents, please understand both Madrid and PCT. Imagine that there is a cloud. So you file it in India. From the Indian application, it goes into an international cloud. For trademarks, it's called Madrid cloud. And for patents, it's called PCT. PCT is Patent Cooperative Treaty. It's not rocket science. But through this system, you need to designate which countries and which territories you want to go to. Once you designate those countries, then it will get nationalized. It will crystallize. Imagine that cloud starts raining into a particular country. Then you need, after some time, you choose whether you want to go into those countries or not in the patents world. But in the trademarks world, you already pre-filed the fees. Therefore, it automatically goes soon after going through the Madrid protocol. So another example I wanted to show that there are colors which can be protected. This is pink in color. All of us know what bottle comes in green. So if I say green color bottle in water, everyone knows this. So single color can be trademarks. It's very, 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 very rare. Recently, we got a wonderful order for Nivea that blue color, deep blue color is Nivea's color in at least the personal care world. So if you go to a supermarket, you've not seen the brand in writing, but from far you see dark blue, you know it's Nivea. So I gave this example also. So no one else in the world can use the red sole in a shoe because they have registered it. So this luxury shoemaker has registered it as a brand, not as a patent. Some countries have allowed, some countries have not allowed. So single color is not registrable normally. It's a combination of colors which are registrable. But there are some exceptions. As I said, combination of colors can be red and white. If you imagine that your customers are in tier 2, tier 3 cities, if they are semi-literates or illiterates who don't read the language in it is written. I'm not saying they are illiterates, but they might be literate in Tamil or Hindi or Gujarati or Marathi or whatever, but they might not know English. For a person who's seen Colgate always, and they know it's a tooth powder or a toothpaste which comes in white and red packing, and they've seen it for 30 years, and suddenly they see another packaging which comes with something written on it, but I know it is red and white. That's what a brand does. A brand is a recall of color combinations as well. Like what you just told me that the green is for Bisleri in water color. So sound marks are also registered. I'm not sure if the sound will pop up from here. We will try. Yeah. So that's the Viacom Colors TV commercial. So all colors, whether it is colors Marathi, colors Tamil, colors Telugu, colors Malayalam, when you hear this, it means it's of Viacom, as in colors channel, COLORs without the U. This is probably more easy for you to remember. This is for ICITI. Yeah. So shape, as I said, like the Coca-Cola bottle shape, there is a lighter which is called Zippo. This shaped lighter no one else can make. They have registered that shape. So I'm saying bottles come in different shapes. There are designs and ridges to it. This is a regular shape, but the pattern on it is design. If the shape itself is unique, then it comes under the trademarks. Patterns go under designs. So we'll just come to that. There are some places, including India, where the store itself is registered. So when Apple went to the trademark office and said, all my stores around the world, even if I don't put the logo out, if I'm across the street, someone sees this configuration of a store, then it becomes my store layout trademark. So all the stores of Apple, at least in the US, not in India, imagine stores in India don't have a uniform standard store format, but at least in the US they did that. And similarly in India, some of us in my previous avatar, we were able to get a registration for Godrej interior design store. I mean, Godrej has furnitures like this, right? They make chairs, so when you go in to buy, they have a section where they sit with the customer and show them the miniatures. So this is standardized in all their shops, and this standard format of store layout they have registered so that no one else has it. There is a touch screen here and there's a TV there, discussion area. And similarly, if you have gone to Delhi, if you are in ITC and there is a Bukhara restaurant, they have every patron who goes, sits there and orders, whether you like it or not, they give you an apron. You have to wear a bib so that your shirt or your kurta or pajama doesn't get soiled. So that checks, like the Burberry checks, is also registered and protected. And someone in the US came out with Balak Bukhara, which means that young or kiddie Bukhara, and that we got them stopped. Another thing which is important is all of us start using celebrities' image, celebrities' voice. When I say us, many in the industry, in radio jingles, there might be Amitabh Bachchan voice, there might be some other popular Sachin Tendulkar's voice, Mahendra Singh Dhoni's voice for marketing and advertising, which is very dangerous. Dangerous by saying that they have rights to stop their photographs or video or audio or voice from being misused. So, how many of you know who this is? Some of you, okay. Daler Mehendi. I mean, if you were born 20 years back, you might know him, but he's out of action. So there was actually a toy which came in from, so this is how there is a unique. So I'll just stop it here because it's a bit noisy here and it's not very good copy. So the actual original song is copied. The way in which he dresses, I mean, he doesn't go to bed in this kind of a figure, but That's how he always dresses up, overcoat and a turban with a gold hanging around his turban. So he has got a unique personality and a unique way of singing and dancing as well, which got copied in a toy, and he was able to stop the toy manufacturer from copying his own image. And similarly, the last 3-4 months, other celebrities have also started going to the courts by saying that completely unknown persons who I have not authorized have started using my voice and my photo or caricature or a silhouette and misusing my celebrity status for selling their products and services. So please, if you think of a marketing angle, either we afford the celebrity or we don't use the celebrity's image or voice or whatever. So anyway, there are other examples of how companies use these. Down south, if some of you are from this part of the country, it's a very popular masala company. Someone copied it as a restaurant also. Even though this company does not have a restaurant, the popularity is so high that everyone will start thinking that that masala company has opened up a new restaurant as well. So it need not be in the same category. So you might say, look, Repute is only a water bottle company. I'm going to come out with a reverse osmosis company called Repute. Can I do it? I have a new technology for reverse osmosis of water. Can I do it? It need not be water. It can be something. But if Repute is a brand of such a reputation, it can go across classes and stop them as well. So you need to be careful of what brands you use. Senior person who's already used the brand, if it is so popular that Uni4, how many of you know? Because you see it every day in the hallway, right? It's a $1 billion baby from here, right? So will you use Uni4? You might say, no, I'm coming out with a medical technology. Uni4 does not do medical technology at all. So it doesn't work that way. So is the case. So Mercedes-Benz, it's a very, very old case where someone wanted to sell undergarments using a similar symbol. That was also stopped. Levi's as a pocket stitch, which is also protected, which is this V-stitch. So if the Levi's label comes off also, but if a person sees a pocket and that stitch is there, everyone knows it's a Levi's trouser. So that is also protected. So I can keep going on. Another thing from a marketing perspective is that one needs to know that your marketing tools, if you want to have a website or even within Amazon or e-commerce, I heard some of you say you are in e-commerce, right? Someone? Yeah. So if you go inside the e-commerce site these days, similar suggestions keep coming up. Because if you go into Flipkart or say Amazon, and you start typing torch light, even before you finish typing torch, they will give you options of what are all available. Torch hanger, torch battery. So that is what is called a keyword. So AdWord, keywords. So when you start typing something, so for example, this is a very old search I propped up. I search for iPhone, and the ad would come up of a competitor, right? So it says awkward, you obviously meant the competitor. So it means the competitor has gone to Google, bought this brand name as an ad word and placed their ad above the search results which start coming below. So you need to be careful about what you purchase, whether it's a trademark. Google might not be liable. Google is making money no matter what happens. Correct? Because they are an intermediary. So they are protected under the information technology law because they are only an intermediary and they are protected because you go there to facilitate something and you choose what AdWords you want to buy, so on and so forth. So there is a case which went all the way up until the apex court. I can take a full day lecture on AdWords and Google keywords, but not for today. Again, when you choose your online presence, whether it's in the Play Store, whether it's in, not many these days are using websites anymore as a primary source of information dissemination, but still it is still popular. So under this, you need to understand that there are different types of extensions, right? TLD means top level domain. CCTLD means country code top level domain. So country code means you have a .in for India, .uk for United Kingdom, .USA for obviously USA. That's country code. And then top level domain names are these. These are all the top level domain names which are controlled by World IP Organization. And there is a UDRP, as in United Domain Dispute Resolution Policy. Our brand or our website is copied by a third person, they have a similar sounding or a similar misspelled domain name, you have to go and complain it to the world, the WIPO overseen United UDNDRP, United Domain Name Dispute Resolution Policy. So we need to, that's the UDNDRP I'm talking about, Uniform Domain Name Dispute Resolution Policy. Or at the CCTLD, country code top level domain name, we have in India a separate policy under which we can go. I mean, you don't need to go to the courts. You just file an email, the complaint is already lodged, hearing also is not there, everything is decided and they'll send back the decision within 2 to 3 months. Right? From a contract perspective, those of you who have online presence and online sale and online delivery or software as a service, any transaction which happens online, you might think, where is the contract? In the good old times, you need to have a contract signed between two parties physically. But in the online world, everything is electronic documents and electronic contracts. You send me an offer, I agree, everything is digitally signed, tick, 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 I agree, done. But when you press agree, you as a seller or you as a buyer, do you know what all you are agreeing to? No? Have you bought products online? Have you returned products after buying them online? So what did you check before returning?
4 to 5 conditions like 7-day return policy.
So those are the terms and conditions we are talking about. So if you are an e-commerce player or software as a service, you need to give out your terms and conditions of sale. These are the conditions. I give you warranty for 1 year, or I can give you full money back return within 30 days, or these parts are replaceable. This is my annual maintenance contract, AMC. So when you come into the e-commerce and everything happens online, don't get frozen, but don't take things for granted. What happens for a lithium ion battery will not work for e-commerce. This shirt which I am wearing might be stitched. It can't, I mean, a person who is 1/3 my size cannot wear it. So yes, as a startup, initially it might be difficult for you to draft 20 contracts for one website, but it's important you tailor make it for your needs, your terms, your conditions. These I'm talking about. TNC, return policy, privacy policy. When it comes to privacy policy, you need to also understand data protection law is coming into India. If you are into health tech, you are into e-commerce, you are into med tech, you will be gathering data from customers. Name, number, age, health, conditions, physical conditions, medical conditions, allergies, your credit card details, swipe details, date of birth, CVV, whatever it is, are all personal data, right? When it becomes personal data, there is personal data. Therefore, you need to obviously understand when you collect these data, you need to handle them in a way which the Indian data protection law is going to tell you. I mean, that's again, we need a whole day for seminar on data protection, but if you are Not in e-commerce, not in medtech also, but if you have customers who have bank accounts, you need to send them money or they are sending you money, you are collecting data, you need to ensure that data is properly maintained. And if you have servers outside India, what happens if you are getting it transferred to a data protection center or a data analyst person, you need to ensure that terms and conditions are as per our laws in country. So, I'm going to skip this because it's a bit legal technical. So, this is a slide which only says that if I make an advertisement and there is a storyline in the advertisement, the laws in the country are protecting even storylines in the advertisement. Conceptually, a party A cannot copy a party B's story, right? So just think of it, understand that and leave it at that. I mean, when you are making advertisements, when you are going to an advertising agency, you think of this slide and say that it has to be an original story. Don't copy someone else's story, whether you're making a movie or even an advertisement for your own company. There are so many company names and so many brand names we heard today. I didn't want to pause and check if it is a good brand or a great brand or a descriptive brand. When you are naming your children, there was a time when Shah Rukh Khan was Rahul in a movie, all the kids will be Rahul. Correct? But in the last 10-15 years, every kid's name is so unique that it's very difficult to pronounce the names also. They take the father name, mother name, fuse it together and make some new names. I mean, it's a recorded conversation, I don't mind. So I had a friend of mine whose father and mother was Shankar and Sumati. They'll become Sumankar and Shanmati. Shanmati was an actor. And Sumankar is my school junior. If he's listening, I'll give it to their parents for coming out with unique names back 40 years back. But if there are words, say fly high and fly higher, can Frank Finn stop Vistara? Maybe not. Because the words are so basic to that industry, it can never become a trademark. Similarly, basket and basket, very difficult. But if you choose a brand like Big Basket, you will have to understand that there will be many more baskets to come after them. So when you are choosing the name of your company or product, whether it's a sub-product or a subcategory also, spend that extra half a day in naming that product well. So I'm going to skip certain too many brand related issues, but here is a company which came out with a, those of you who like a drink or two occasionally or more than occasionally, when you want to carry your alcohol, they came out with a flat hipster which can be put into the pocket like a wallet, right? So that it doesn't bulge out. So they came out with this, and there was a person who came out with a similar looking concept, but eventually the court said that there are too many rectangular bottles with rounded shoulders and there is nothing unique about it. So they were not able to stop such, and the uniqueness is not so unique that this shape could be protected. Anyway, so brands, any more questions? Any questions at all? So you will ensure that your company names and kids' name will be alike, unique. Okay, good. So copyright, if we can quickly run through, are, according to me, are the broadest form in the 5-6 buckets of intellectual property. There can be literary work, there can be artistic work, there can be cinematographic work, there can be sound recording, there can be musical work. You might think all of them are movie related. Not necessarily, because your software, which you are writing millions and millions of code, are all under a subcategory of literature, right? Software has been given a separate category, but if you write a book or if you write a database or a table or a compilation, it all comes under the category of literary work. So drama is a bit different because a dramatic work, it can be for a dance choreography, a musical, or a dance drama, a stage play, those kind of are in the dramatic work. And quickly moving on, musical work is different from the songs or words. So if there is a orchestra or a big Zubin Mehta, I don't know whether any one of you, in our ages there was a big music notation player. So artistic work again are a very, very broad form. All of us have phones, and all of our phones have cameras. I mean, I don't want to ask an embarrassing question. Does anyone have a camera without anyone has a phone without a camera in it? No. So all of us are, okay. So all of us become photographers, right? So whatever photo you click, I mean, if you are taking a picture of me or I am taking a picture of you like this, I become the owner of that work instantly, even though you are all in it. Whether you liked it or not, I took a picture. But anyway, so something like that is like painting, sculpture, drawing, photograph, architecture, all of them. So it's a very broad category. So if you have engineering drawings for your products, those all form under copyright. Now you might ask me, what is the difference between copyright and a design? But we will come to that later. A rudimentary engineering drawing of a product is under copyright. But when you apply that drawing onto a materialistic object, so I can have a drawing of this, but when I transfer the drawing into a 2D or a 3D, then it becomes a design. So the basic work is the copyright. So, and then there are cinemas also, and then there are sound recordings. For example, my friend here is recording the video here. That's a cinematograph work. The owner of the cinematograph work is IITM RP, Research Park, because they have hired him. Though he is the author, IITM Research Park will be the. So there might be a photographer with a camera. I might be a photographer with a phone. If you ask me, I'll give you 100 rupees, please take a photo of me. Even though it's my camera and my phone, I took 100 rupees, the photo belongs to you. Like how you go into a passport, Konica, and take a passport photograph. You pay money, the photo belongs to you. Same photographer comes out and takes a photo of you, that belongs to him. So it makes, so very shortly put, in a copyright, please understand who asks for it, who commissions the work. So if you ask your friend to make your company logo, who owns it? Friend is the creator. If you have paid him and he has transferred it to you, then you become the owner. Yeah, friends, if they remain friends forever, it's good. Not in a corporate world, right? Today's employee is a former employee tomorrow. Today's friend may not be a friend tomorrow. Same friend can go and sell it to a water bottle manufacturer. Same logo can be used in two different formats. Provided you buy all the rights from that person who created it for you. Whether it's a software engineer writing the codes for you, your employees, your friends who are coding, you need to have all those agreements in place for you. So this is only to ensure if you outsource anything which is not done by your employee, get agreements to funnel it back to your company. Whether it's a software by a consultant or a student or a, what do you call them, hired consultants, or a logo creator, or your website designer, anyone who's not your employee, you need an agreement back to you. So anyway, these are pictures of all those. I'm going to just pause and say, in a cinema, there are about 10 or 15, this is very short list here. There are about 10 or 15 different rights in the same work. There will be dialogue, there will be music, there will be script, there'll be music. I mean, you can keep going on and on and on. Lyrics in a song, the cinematography, there are so many rights which one producer has to have thousands of artists signing. There'll be hundreds or thousands of agreements also in place. But each right are separate and that producer needs to buy them all. It's a one page, two para. I hired you for money, for so much money, I paid you on this day, you receive it, all rights in it belongs to me. I mean, it can be as rudimentary as that, but as long as you have recorded that you asked them to create it for money, you have paid and they have transferred all rights in it without any reservations. That's about it. As a subdomain, so the subdomain contents might belong to you. So I might be having a godaddy.com and subdomain might be your company which they are running it for you and they created it for you. The subdomain might belong to them, but the contents are yours. The information and the logo and the literature which is inside are all given by you and they created it at your instance. They might be hosting it for you. But when your agreement, so as my friend says, it's my friend, why do I have to pay him? GoDaddy might be hosting it. If your agreement or renewal contract is not renewed, you are still entitled to scoop out all what is there and go park it in some other domain. But all those content are yours. They cannot use it elsewhere. They cannot continue to use it unless you give them permission, though it's their domain or subdomain. So, software, I mean, of course, Maha is here from the software domain. She's a software engineer, bachelor's and master's, my colleague. But software is something which has to be protected both as a copyright and as a patent. Patent with certain subject conditions, but we'll talk about patents in a few slides. But as I said, the codes per se are copyright protectable because they are millions and millions of code. So if we have 30 of us and we are doing a source code cracking competition today, you might be doing the first 1,000 lines, 1,000 lines, 1,000 lines, all of us stitch together and make one platform. Now, each of you might be the employees to that organization, but the organization owns the whole bit. So one employee cannot take and say, oh, 100 belongs to me, I'll go use it somewhere else. Whether it is 10 lines or 100 lines or 1,000 lines, it belongs to the person who owns it. So the codes are like chapters to a book or paragraphs in a chapter, right? Whether you copy the whole book or a chapter or a paragraph in a chapter, copy is a copy. Copyright law does not say 10 lines is okay to copy or 5 seconds in a music is okay to copy. There is no exception.
But if the part of the code is available online, so it will be called as copy.
So you need to obviously say whether it's open source or not. So there are two, most persons make a mistake of saying that, oh, I found this logo online, it was free to use, I used it. What is available online does not make it part of public domain. It is available for you to see. Do you have the permission to use it? You need to see whether it is free to use or not.
The MIT license and all.
Yes. So when I say MIT license, when I'm just nodding my head, presuming that you're talking about open sources from various different modes. So even for photographs, there are Getty images which you need to pay. There are some other sources where it is free to use. So free to use photos you can use whether with or without watermark. But I'm only saying it's important for you to understand that all of what we saw in the previous ones, no part of it is free to use unless they, as in the owner says, yes, please take it for free. But it's better you get it in writing rather than saying, oh, I found it online, it was right clickable, left clickable, I did a copy paste, therefore I'm free to use. That's not how it works. You can get a certificate of copyright. You can apply for copyright and get it registered. It's not mandatory. The minute you create a work, whether you've made a doodle of me, board of this lecture on your book, that belongs to you. You don't need to get it registered. But if you register it, it's easier to prove. So if someone goes and copies it, you can go show the certificate and say, look, I've already got a registration, but that's not mandatory for copyright. For patents and designs, it's mandatory. Trademarks and copyright, not mandatory. Because patents and designs, for the reasons I'll show you in the next slides, when you launch a product without application, you've made it public. So the innovation part, not the creativity part. Innovation in the technology or innovation in the process or in the design, if you have not filed for a protection, you are giving it free to the public while you launch it. That takes us to the key mid part of the session today. What is a patent? A patent is nothing but a quid pro quo. Quid pro quo with who? The government. I come out with an invention. The invention can be for a product or a process or a method. I can keep it in my pocket, not telling anyone at all what the invention is. But how long can you keep a secret? Within 5 persons? 10 persons? It can remain a secret only when the first person opens their mouth to the outside world. Correct? So it's a quid pro quo with the government saying that I have an invention, I'll come and disclose this invention to you. In return, please protect me for 20 years. So that's the quid pro quo, but it comes with certain rules and regulations. What are the rules? 3 rules. 1, it has to be novel, means it is not known anywhere in the world before. That's the novelty test. Second one is a non-obviousness test. That person like Maha, who is a software engineer, or person from the lithium battery world in that field of art, should not feel, oh, this is obvious. This is not an invention. You put A and B together and called it AB, how can AB be a new invention? I'm making it as rudimentary as possible because you're all from very varied fields of science. So it has to be new, that is novel. Inventive step, yes please. Absolutely. So the end result need not be novel, but if you are bringing in efficacy, efficiency more either in the process or in the end product, you have improved the life of a product, or if you have improved the non-corrosiveness of the product, like lifespan of a product. The methodology 90% is the same, 10% you are tweaking the method of production in your battery world, then the result is not new. Result is elongated battery life or elongated the energy dispensation, whatever it might be. So the added layer of the newness, which was not existing, but the 90% which is already existing will be the known prior art. And what you have brought new to the table can be carved out, and subject to these 3 conditions, we can claim that that is your newness, invention, innovation.
So in that case, we have to file the patent on the material side or the product side?
That is subjective. It can be both. You can file both. You have brought a new material which brings the newness, or it's a new process which brings the business. You can either file it both as a single patent, or if it is completely parallel and can be livable next to each other, you can file a method patent, or you can file a product patent also. So believe it or not, I mean, it's just namesake. 1891 is when they had perforations in tissue paper, right? But someone actually patented the perforation, because until then there was no perforation. Everyone used to tear off wherever they wanted, and it used to tear unevenly. And so also is in the milk carton. Milk carton came out in 1916. But what is the innovation? Exactly the question you asked. correct? When was the first standable, foldable carton came in? 1916. But still market leader is who? Tetra Pak. It's a company, of course. I mean, it's a brand as well. So if you actually look at it, they would have added layers and layers and layers. The inner layer might be different from different products. One might be oil, cooking oil, one might be automotive lubricant oil, one might be drinking milk. So the methodology to make this, so I'm saying from 1915 or 1916, I don't know what the number is there, the product was already there. But in 2024, they are still relevant because they might have kept improving or adding either the material side or the process side to have newness or innovations in the same field. That's precisely what I gave the example here. The term is for 20 years, but you need to renew it periodically, annually as well. There is an annual annuity which you need to pay. You can ask why can't you pay for 5 years or 10 years, but there might be, in the good old times, there were patents which were filed today granted on the 18th year due to backlog. So you might renew it only for 1 and 2 years. So you can't, it's a waste of money for filing a renewal of a non-granted patent. So that's why it's called annuity. We call it a negative right because it's not an exclusive right, but it's a right to prevent others. But leave that nomenclature to lawyers like us. Just say you've got a patent, it's good enough. Because its exclusivity is in trademarks, preventability is in patents. So it's a legal difference, not for you. So as I said, there are a bunch of requirements. The first 3 requirements of novelty, inventive step, and industrial applicability. Industrial applicability is whether it can capable of being applied industrially. So that's why we have a separate section 3 which lists out a long list of subject matters which cannot be patented. Like the government says atomic energy is mine, don't even try getting there. It is not given to a common man. So there might be certain exclusions. We can quickly see what these exclusions are. So at least I'm going to skip that because it's for medical devices. Some of you are from medtech. But if you actually see, there might be, it might be for formulations, or it might be for processes, or it might be for salts. So it might be for the method of delivering the chemical, or it might be the end product itself, as in the chemical entity itself can be protected in at least the pharma world. What are all not inventions? There is a long list. Living organisms, or frivolous or contrary to natural law, or it can be also in the pharmaceutical world. 3D is the most sought after or fought over provision about 10 years back, because it says if you have a known substance today, you by chance find a new applicability for it. It's a known substance or a known process, but if there is a new form or a new property, then you'll have to obviously say, no, please hold on. It's not just a mere discovery of a new form or a new property, but there is enhanced efficacy. So those are exception to an exception. I'm not complicating your life today. But if there are 100 million or 10 billion products in the world, this list is not patentable, with certain exceptions to an exception also. Am I confusing you enough? Yes, sir? Okay. So anyway, so this is something which you can relate to, 3E and 3F, right? So some might say, I have a watch, I have a water bottle, I saw this water bottle. It actually tells the time, or it might show the temperature of the water inside. That white bottle right there. You tap the top. Can you have a patent on it? Maybe not, because it is a mere rearrangement of known devices. So if you, that's where it hits a lot of times on, don't put together and say that I've got a new admixture or a new set of known devices. So, I mean, then the list keeps going on, whether it is plants or animals, seeds, essential biologics, so on and so forth. And for some of you, this part might be interesting from the engineering side or the software side. Maha and team would love to talk about it on a full day basis. But the word which is key here, which my slide does not have, is the word per se. So assume that there is a word per se here. So if it's a computer program or algorithm per se, then it is not registrable. So if there is a compiler, if it's a word processor, can you patent it? No. That's precisely why we were saying if you have a software along with a device, along with the hardware, the combination can be protected as a patent which has a software in it, but not a software standalone or an algorithm standalone per se. So the list keeps going on. So even traditional knowledges in the medtech world, if yes. So to take it very rudimentarily, if it's a boot software which boots the system which runs with the device, maybe, yes. Or if there is a software which runs the IC circuit, which enables the IC circuit in performance or increased performance, maybe. But if you have a standalone software, which is just a word processor or a compiler, maybe not. I mean, I'm giving it as basic as that, but there are further deeper analysis to it, but I'm not getting into it just now. Like TK, as in traditional knowledge, you might have seen all the fights about the turmeric and the efficacy that it brings in. So traditional knowledge, all of us know that turmeric is good for health. It is an anti-inflammatory. Any person who tries to take turmeric and then converts it into a patent, we'll have to go after them saying that 3P excludes it, so you can't patent it. So, insofar as the chemistry is concerned, you need to have enhanced therapeutic and efficiency, as I said. Otherwise, if you have new chemical entities, you need to have a novel process or a novel substance, API or a new chemical entity. If there is a new form of a known substance, then it has to be married along with the enhanced therapeutic efficacy. Again, same like devices. If you are working on a physical device, I don't know how many of you, do you have anyone here having physical devices? Okay. Yeah, I mean, but is that your mobile? I mean, are you making the device is what the question is. Okay. So they might be medical devices, HVAC, as long as these 3 or 4 items you need to understand. As I said, the novelty, inventive step, industrial application, and the list of 3 exceptions. If you cross all 4, then you can have your patents granted. So, as I said, what happens in a novelty problem is, if you are enthusiastic as a student, some of us will have a college exhibition or cohort or some event or some competition which you go to, or you have your own Instagram page or Facebook or social media page, you go upload this device or your innovation or invention, you are instantly killing the novelty in it. But you are allowed to do it after you file the patent application. But if you go ahead and tell the world, this is my invention, without filing the application, you are flushing it down the drain. right? So there are 90% of the problem comes when there are clients who come to us and say, now it's the time to patent. Okay, we say, what is the novelty? They will talk about the novelty. And then we ask them, when are you going to launch it? They'll say, no, it has been in the market for a year and a half. Then we'll have to say, I'm sorry, we can't do it because you've already launched it. Customers have taken the product, implemented it. If that device is not working or process is not working, they will go to your competitor and say, can you make a similar device like this? You've not filed a patent. They are free to copy it. So, important part is to do what? Before announcing, launching, sharing with friends, family, what happens inside your four walls is for you to enjoy.
What if somebody else makes a similar product after that?
So, your ability to stop them starts only when the patent is granted. So, the patent grant in modern India is coming as early as 10 months to 12 months on two conditions. You can be a Startup India registered entity or an MSME. That is condition number one. Condition number two is you pay an extra fee for an expedited grant. Then you skip the long queue and go through the Tatkal system. Then your entire examination, hearing, grant will all be expedited. You can take a watch of your competitor who is copying. You can either send him a notice saying that, look, I have filed a patent, it is going to be granted soon. Once it is granted, it will be a violation of my patent. But there is a problem. This is universal. If you send him a notice and tell him about your patent, he can come back and oppose your patent to ensure that it is not granted. So normally persons, what they do is they file a patent, even if there is competition, they will wait, expedite the patent grant as much as possible and then initiate a legal action. But if you think that your patent is a bit hatke, as in completely new and unique and not known, then you can let them also go through the opposition process. Probably it will add 6 months, 8 months of time for the opposition proceeding to get over. If you are strong on merits, it will be granted despite the opposition. But if they are able to show that it is already obvious, not novel, then the patent might see a different end. Mm-hmm.
Some process is very well known, and some company has done trademark for that particular process.
Patent.
Trademark.
And the process comes under patent.
No, actually, we have seen that here, some process.
So that is the brand name for the process. So the process itself will be protected as a patent. So for example, if there is a free flow, right? Free flow is a brand name, but the process is under the patent. So you should not copy the name, you should not copy the process if process is patented also. What is your question? I stopped you midway. So don't use the trademark, but you need to also check if the process is patented.
But that process everyone are using because it's a well-known process.
So that process, if it has gone beyond the 20, so if that company who trademark or branded the process name has also got a patent for the process, it will be only for 20 years.
Yeah, but that's what I'm wondering because already literatures are there, many literatures are there on that. So whether is it possible to get a patent in that?
It is subjective. I mean, I can't tell you across. We need to sit together, study how crowded the market is. That's called the mapping of the industry and the mapping of infringement. We need to do a search. I was just telling someone prior to the start of the session, there are two types of patent searches which are done. One is a infringement analysis search to see what you are doing is already not patented by someone else. So you will go to the Indian Patent Office and search only for patents if that process is someone else's patented process or not. That type of search is very, very limited. You are only going and seeing if there is a patent or not. But when you have to file a patent, it's a patentability search. That is the world over. You need to see whether someone in Malaysia or in Qatar or in Peru or in Iceland has already talked about it and it is already a public knowledge. It need not be patented. But if it is already public knowledge, you cannot patent it. So, to answer your question, we need to study if that party has got two types of IP. Name of the product is the brand, which is the process's name. Whatever the process name you said. What is it called? Accuse process. That's the name. But the method is the process by which they are doing. You need to also see if that method or process is patent. So you should not copy the brand name, you should not copy the process if it is patented. But if you are saying that there are too many literature already, because a patent is granted, there might be public knowledge of it, but still it can be patent worthy of protection. So if 2020 I come out with a new product, I apply for the patent in 2020, it is granted in 2024, this year, it becomes widely known, but it is not free to use. There might be literature by saying accuse process, this is the process. But can you use it? You need to check if that is patented and if they are protected by a patent or not. So just because the process has become published, so my invention, the accuse process, if I am the inventor, I apply in 2020, I describe what the patent is, how the process is, I go to the patent office or file it, they grant to me in 2024, then it becomes known to everyone, but it is not free for everyone to use. There is a slight difference. So if it is known for 20 years plus, it has come out into the public domain, it is no longer patent protected, you are free to use it. Or no one has filed for a patent, it is a well-known process, it is a generic process without any patent protection, you are free to use it. That's why I said you need to do two searches. You need to see if others have already registered the same process and if it is still valid, then you cannot use it. But when you go to the patent office to file your patent, patentability search is wider than what is already patent. It can be a research paper in IIT Madras or in Korea also. So, moving on very quickly, what is not functional is a design. Just for the looks of it. How the product looks. So the very same pointer device, there can be 20 shapes. But the function which it does is to left and right button along with the red, infrared rays. But the looks of it might differ. That is protected under a design. The shape, configuration, line, pattern, ornament, etc., are all under the design. While patent is for 20 years, design is for 15 years. Patent is all about functionality, design is non-functional. So it might have an incidental functional aspect, but what design protects is not the functional aspect of the product. It's only the looks of it, whether it's 2D or 3D. So example is, what does a front grille do? What is the function of a front grille? Anyone? For air to come in, for the suction which goes into the sparking of the fuel, etc., or even the radiator cooling. But each grille is looking different. So this is the difference between a design and a patent, right? So, for example, you have a boiling pot. What is the function of this? To boil water or boil a liquid. Even this does this. I might buy that for 100 rupees, but this might be sold for 100,000 rupees. Why? Because it looks different. It looks unique. So the commodity price might increase for the looks of it. I mean, on a lighter note, why is iPhone better than Samsung? I mean, brand is better and design is also better, right? So similarly in chairs as well, functionality aspect goes into the patents and the aesthetics goes into the design element. So I was just giving an example, right? So that might be sold for $5,000, it's for $12. At the end of the day, you're going to have a seater. The function is to only sit. So we did this case, which is very quickly. This is a company which is owned by Philips. How many of you have seen a Polycom conference table speaker on the table? Yeah? So have you seen the shape of a Polycom? So I think, I don't know, I didn't check with them, though I was part of this case. They got inspired by the bottom of the Polycom and then lifted up a motor and then made it as a bottom of the mixie grinder. So there was a competitor who came out with a similar arched feet. So there was a fight between them. The court said, look, in design law, concept is not protectable. In this, the switch is on the leg. There are 3 legs, 1, 2 and 3. The switch is on the leg. Here the switch is between the leg. So that design is different from this design. It is not exact replica. So concept is not protected, but actual visuality is protected in design law. So I just wanted to give a quick perspective on it. We've covered this, so I'll skip, I'm sorry. It's good to know that GI is geographical indication, whether it is Kolhapuri slipper or Kanjivaram sari or Coimbatore pumps or Coimbatore grinder, Madurai Malli. I don't know how many of you are from the south. I'm only giving South Indian examples. Or Tirupati Laddu. So advertisements, I've already told you that it's absolutely important. So if you take one product, there might be many IP in it. So if you look at one advertisement of one product, there is a word mark here. There is a color combination here that is also a brand, correct? The way in which the nozzle sprays might be a new device or a patent. The product inside, which is also a pain reliever, might be patented. This is entire advertisement is a copyright because there are a lot of literary work in it. And there is a celebrity right as well, correct? So I just wanted to give you a perspective of one picture which has many rights, so for you to involve. Online use and protection also, I've given you examples saying that if you have online presence on social media, if someone else has copied your photograph, if someone else has copied your personal photograph or company brand, there are ways in which you go to this 3 button and there are reports, and when you go and report it, you can say, why are you reporting it? And then there is an IP violation there. So online misuse, there are mechanisms by social media websites. If you have a website, you should have this on your website too. I mean, if you are an e-commerce platform, right? Because third parties are coming and posting products or listing on your website, you need to ensure third parties are not using your platforms to violate third party rights. So anyway, if your IP is violated, as I said, you find the 3 button, find the report, and then go and file a IP right violation, and then you talk about what is the IP, what kind of IP is being violated, and so on and so forth. Right? Any doubts on that? So I've also given a similar example of the same product, 2 competitors, right? At this end of the day, it's almonds, nothing else. The shape of the packaging is different. That is the design. design of the packaging. So even if you have a new package, it can be protected as a design. This is the brand name. Here is a Natraj and here is a Naturos. This is the product name. This is the geographical indication. It comes from California. It indicates the origin, the source. And then you will have a copyright on the color combination or on the device and the photographs also on it. So you've understood trademarks, patents, copyright, design? Yes? Why is design not called trademarks? Trademark and all these guys overlap. All these guys overlap. Right? So this repute can be written in 20,000 fonts, but they have chosen this font. It can be depicted in 50,000 colors, but they have chosen this color. So the repute word can be a trademark, but it can also be a copyright because it's written in a unique way. It's written in a color combination, therefore it can be a copyright and a trademark. So it is an overlap. So I can understand all of us getting confused. I want to copyright my trademark or trademark my patent or patent my trademark. It will be confusing. Leave the job to us. Right?
And sir, why design is for only 18 months?
15 years. 18 months can't bola. Who told you? Please rewrite that. It's 15 years. 5 plus 5 plus 5. I'm sorry, 10 plus 5. Yeah. 10 plus 5.
And how much time it will take for design?
That's quite fast. It comes under 5-6 months. So I've tried to give you technical lawyers' words, normal diction words, in a way it's easily consumable. Right? So trademarks are brands, patents are inventions, designs are for the looks of the product, copyright are for all the art world, any creative world. GI is where does it come from, geographical indications where the origins are, but those are for physical products only, not for technology. Trade secret is something contrary to patents and patents. So there are times when not always you want to patent your product, because when patents, what did I say? It is a quid pro quo. You need to tell the government for them to give back the 20 years of promised exclusivity or preventive capability for others. But here, mostly in the food industry, perfume industry, or I'm trying to see some technology industries, that they keep certain parts of it as trade secret. So in patents, you might give the method and the process or the end product, but you need not give the exact methodology or what time, what temperature, what admixture. You don't need to give the best working method. You can give the working method, it's fine. So the way in which perfectly the patent works, you need not disclose. They can see your patent and copy it, but they might not be as successful as you are because you know the best working methodology, which can still be kept as a trade secret. But the most important part in trade secret is, because it's not a quid pro quo with the government, you need to protect this. For this, you need contracts. For this, you need 10 layers of lock and key, not physically. It might be electronically as well. The club which you create in your team, this person's salary is 10,000. In 15 minutes, it will not be a secret, right? So you need to have processes, jokes apart, a very extensive process by which trade secrets are controlled, managed, shared and protected. So it's not very, very easy to protect trade secrets. Contract is a start, but how you protect it. So for example, luxury brands which make the best jasmine or certain unique perfumes, say like Fahrenheit is a Christian Dior perfume which is so unique. It's very, very, very difficult to know what all go in there. You might get the perfume, take it, rip it apart, but how do you get that smell again? So that's all protected under the trade secret. Only 5 or 6, some cola companies like Coke also have their syrups which are protected under the trade secret. So
What if somebody else stumbles upon that? Can they file
if they stumble upon it, it's the bad time for the person who owns the trade secret. That's what Tom Cruise does in most movies. He stumbles upon it, and so it's in the 20th floor, and then between 3 walls, and then so you need to ensure that those stumbling doesn't happen. So you can have a contract with your employee and say, you are going to be exposed to confidential information, but you need to identify what those confidential informations are when it is being given. The agreement which you are writing for confidential information will not have in the annexure ABCD as the trade secret or confidential information. But when it is being given to that person or sent to the person electronically, you will say this is confidential. Every time you impart with that knowledge, you will have to mark it confidential. Whether to your potential investors also, whether it is to your mentors also, whether it is to your vendor also, mark it confidential. Whether it is confidential or not, it is better. It is subjective and much later. But you need to mark and identify it as confidential. We have another 10 minutes to wrap up very quickly. So, the question which you asked, what happens when someone stumbles upon it, or what happens when someone copies it? Again, each one have many options. You can take your trademark list, copyright list, patent list, and go to the newspaper and say, these are my rights, please do not copy it. That's called a caution notice in a newspaper. Not many of us actually look out for caution notices, but they are in national newspapers and dailies. If you know the exact individual or the entity, then send them a legal notice. But the pitfall of legal notices, they will send you a reply back and saying that sorry. But what happens to the pocketed profit, loss of opportunity, revenue is lost, your customers are gone? Then if it's a big size ticket of a copying, then you go to a court saying that, look, this is my patent, this is my design, this is my IP, they have copied it, they have taken away my customer, they've taken away my revenues. I tried a legal notice, but there are sometimes you want to send a legal notice to a small party. But a big party is, if you send them a notice, they'll go to a lawyer and say, please send a notice, reply back. Then there is no closure to it. Physical products you need to record with the customs. I don't know, any of you have foreign manufacturing units for you to import it into India, but these are for multinationals having cross-border. When Bangladesh products are manufactured and bringing it to India, if you want to stop them at the customs, you can take your IP and tell them this is my brand. If someone else imports it under this brand, let me know. Then the customs guys will stop it and take it as a counterfeit. Of course, your adverse enemy, you can turn them into a license. So if you have a patent, the best way in the software industry is everyone uses the counterfeited, pirated software, and then they'll come and ask you, please give me license fee. When you're 10 and 20, they won't come after you. When you become 100, suddenly the pings will start coming. They'll know that you're all sitting in IIT Research Park. There are 10 pirated software here, please give me license. So, point is, if you have someone copying you, you can go to the court, or after court also you can convert them into a licensee and start demanding license fees, right? So that's why we say soft approach, hard approach. Hard approach is going to the court. Soft approach is please help me. Stop copying me. That's a soft approach. I don't know how many of good Samaritans are there that they receive a notice and stop it, or they return all the money they made. They're not going to do it. That's why you need the harder approach. Depends upon what cup of tea we need at what point of time. So we're just giving examples of how a caution notice looks in a newspaper, how a legal notice is being sent, and how they withdraw the brand and give undertakings. And, I mean, funny example, Netflix went after someone who's selling nuts called Nutflix. But, I mean, you might ask why, but that's how power of brands do. Or even water brands like Evian and Evian. So this is an undergoing case because this came up in March, and Komal and Arjun are handling this case before the IP office. And similarly, there is a very big brand called Bounce. I don't know how many of you have gone to the salon in Chennai. So there was a company in Bombay which called, what is it called? Braid and Browns. Braids, as in hair braids and bounds. They used bounds in the second part. And yeah, this is readable better. So we stopped them. The owner did not stop it, and then we got an arrest warrant done. So unwantedly, the person was not compliant with the court order. The court said, please arrest the lady and come. So there was a owner who was a lady who was summoned to the court under the warrant. So if there is a cease and desist notice sent, they don't oblige, you send a suit, you get a court order, they don't oblige, and then contempt can be initiated and you can be arrested and brought to the court. As in you, as in the third party. So the bottom line is, it's better not to do it. And then there are multiple types of orders which you can get in court. You can go break open logs and see the server. We've done it for some software companies. We can break open the logs and see where the physical products are. We can freeze bank accounts of the companies if they are running away with the money they have made, you know. So these are Western words, but at the end of the day, we will go catch the defendant or the thief or the copier or the counterfeiter. So we can seal premises, or we can have community service for the infringer to come and teach that I was an infringer, I have turned a new leaf. So he'll go do community service around that also. So I'm going to skip. So even after you file the case, you can also be granted the cost. So if you are spending on the court fees, the lawyer fees, in modern commercial courts, you are entitled to a refund of those, and also as damages and punitive and the court fees as well. So we just wanted to show that India has become modern. All the IP offices are online. All the IP offices are digital. All courts have become digital. In fact, Supreme Court, when they started in Corona, everything became digital and online. Now you are able to see Supreme Court live. Delhi High Court is live. Madras High Court is live. You can go into any court and see whatever you want, and still you will be able to walk in and see what is happening. Disposal rates are very, very high. But one quick thing, if you know someone is violating your right, it's important for you to take an action immediately. Because if you think, that person is very small right now, I don't have budgets to go to a lawyer, then the court, after some efflux of time, what is it called? Delay. And then there are 2 or 3 varieties of delay. Laches also is form of a delay. Acquiescence is you give a consent. When you are small, a friend of you asks, you talk about friends, friend of you asks, okay, no problem, you take this software, you plug it and use it. Then you have given a consent for you to use. You cannot go back and when they become big, complain later. That's called acquiescence. You've given consent for them to use. Later you cannot complain that they should not use. So don't turn your back against time. That's the whole point of having an elephant's back here against the Time magazine. Don't turn your back against time, because delay, there are limitations where you have to take action within a few period of time, 2 years, 3 years, 5 years. There are limitation periods. When you miss the limitation period, you can never take actions again. So when you know of any misuses, go to your nearest advisor and ask them what to do, and take that action immediately. So I'm going to skip advertising rules because these are all for physical products. but you need to know that there is an advertising um, code, Advertising Standard Council of India. It's a voluntary body. You can go and um, file complaints as well. When you are comparing yourself with your competitor, there are certain do's and don'ts. The green ones are jarring that you can do, red ones are jarring that you can't do. You can say I am the best in the world. You can say I am the number one in the world. I am the leading manufacturer. I am the largest manufacturer. I am the perfect. I am the moon. I am the sun. I am the star. But if you start trashing your competitor, that's where your nose will get cut. You can say I am better than my competitor, but you can't say your competitor is horrible. So there are a lot of advertising concerns which do come. So you need to know that there are disparaging advertisements which are frowned upon. Courts have come down heavily. So if you have a marketing campaign to compare with your competitors, don't disparage them. Don't put them in bad light. You tell that you are bigger than them. That's not a problem. Better than them, no problem. So there are quite some examples. What you cannot say is that competitors' goods are bad or products are bad. So just keep that in mind. Another 6 minutes to go. So what happens is if you defame, then they can sue you for damages or you can sue them for damages. If your competitor is trashing us, you can go after them. You can get damages and you can also get an order asking them to shut their mouth. It's not a one way, it's mutual, right? So example is, I'm just giving you from the court order itself. So if you see any watermark there, it's from the Madras High Court order. So that's why the figures are not very clear. But if you see, this lady is trying to sell these products, which is possibly Lysol, and these are herbal products. This is all in peak corona time. And she's trashing herbal products generally. She's not trashing one brand. She's saying, if I have to use the herbal product, I'll have to use 2 or 3 capsules of it, and then I have to pour it directly from the bottle. It's so much of liquid I have to pour that my consumption of that herbal antiseptic or anti-inflammatory will be very high. But if I use this product, I need to use only 1 cap. Therefore, consumption is less and efficacy is more. And then they are saying that, look, the other one does not kill and it leaves behind a lot of germs. Mine is 99.9%, there is only 1 germ here. So they are basically telling the entire community of herbal products, because this was filed by ITC, their product is called Nile, Nyle, and they were the leading herbal disinfectants in the country and they still are. And this is non-herbal. So anyway, long story short, we are saying that do not trash your neighbor. You can keep your house clean. You can keep talking about your house as the cleanest, best. But what is not permissible is defame the entire category. So I'll skip the other ad also. Similarly, a doctor goes into a kids and then they ask what happened. They show that they used, where is that? They used, what is this? It's the category. They didn't show Dettol, it can be Savlon also. So they trashed the category and then they said, no, you please come and use my Lifebuoy soap. Soap is better because it actually cleans better. So anyway, there are so many other examples like this. I'll just skip this. They say that again chemicals are harmful, please use a shaving blade, for women. The hair removing chemicals are very harmful and the skin is bad. So that is also another example. And similarly, sorry?
I have a doubt.
Yeah.
So we are stashing from all the chemicals, right? So the chemical company can sue us that why you are saying we are harmful.
Correct. That's what happened.
Okay.
Correct. That's precisely what happened.
So we can't do that.
Yeah, you can't. So here ingredients are, they're saying urea. Urea is used for plants like fungicide or insecticide kinds, or it is for fertilizer. Anyway, so they are saying strong chemicals. So the category of the entire community which is using hair removing cream with a spatula were up in arms, and obviously that was wheat, VWET.
But how we can marketize them?
So here,
There's no marketing.
you just generally say no to strong chemicals. It doesn't say the chemicals are from the ointments or hair removing creams. It doesn't say that here. This is allowed. This was allowed. But the same company, same video advertisement showed about the cream as being harmful. So this was also, this was the case which actually hit the national newspapers, which we handled. There is no name of Nivea here. They peeled off the name Nivea, and this is inside the mall, and they were comparing it in one hand and another hand. If you go to Sephora, I mean, the women in the group will know. This side is all women, this side is all men. So the women will know. Sephora, when you go, they apply, and then he was shown that the other cream was not so sticky. The dark blue cream is sticky. So we had to prove a blue tub without the name is still Nivea, the single color mark which I said. And then they were denigrating it as well. So anyway, so they actually, what they did was, Nivea had 3 kinds of products. Pond's has 3 kinds of products. Nivea had a heavy cream, mild cream, and a gel. They took the gel and compared it with my heaviest cream. If the comparison was between these two, we didn't have a problem. Comparison was between these two, we didn't have a problem. Comparison between these two, we don't have a problem because they are chalk, cheese, carrot, orange. But if you take my heaviest cream and compare it with your lightest cream, then it's defamation. Right? So anyway, the court actually said these are the 3 important parts to find out whether there is defamation, whether there was actually an intention, what is the manner of the commercial which was made, and what is the storyline also. Right? So 5 p.m. to the dot. Floor is open. Yeah? Sure. When you are in the early stage of discovery, you don't know what your end product is going to be, but you have an overarching idea of what your 4 corners of invention are, but you don't know what the exact features, exact final process and product is going to be. But you need to start giving that idea to your, say, funding company, early investors. You need to disclose it to someone, or you need to go and give your early findings to an institution, or you need to have a collaboration agreement. But still your invention is not fully ripe. At that point, you will file a provisional and say, this is the version 1 of my invention, but I don't have a fuller idea of what it is going to be. But that provisional will not have the claims also. Correct? Provisional application will not have the detailed claims. It will only talk about a paragraph or 2. This is the line, this is the problem, this is my early stage innovation which I have come out with. I claim this to be my invention. And then you are given a statutory time of what, 12 months, 18 months? Correct. So, complete specification comes with the claims. Claims means, so a patent has got 4 or 5 parts to it. One will have the title, one will have the summary, one will have the history of the industry, and then you will talk about the claim. The claim is the part where you are describing the invention in a legal terminology. So the inventor and the claims drafter will sit down and then claim this to be my invention. So the patent is a 20-page document. First paragraph will be the abstract and then a summary. Summary will talk about the background and all that stuff. Then comes the claim. When someone violates the patent, it means that they have violated your claim. And claim has about multiple parts, primarily two parts. The first, there has to be at least one claim, and then there can be multiple other claims. The first claim will always be the independent claim, which means the other features which are coming. So for example, the famous example I love is the pen, light and a knife. So if this is a pen, I will say this is a pen which will write upside down without gravity when I am in space, and it need not be held like this, etc. But I want to use this pen even in a dark room. I may add a light to it. So the first claim will only talk about the first feature which I talked about, saying that it can be used in space, it can be used without gravity, so on and so forth. Correct? But when the minute I add a light, that will be a feature that might be in claim 2. It will say a pen which is mentioned in claim 1 having a light on it. That will be claim 2. And then if I add a knife to the pen and say a pen in claim 1 and the light which was added in claim 2 has a knife now added to it, will become claim 3. So and then we keep adding those and it will go on till claim 20, 30, depending on the nature of your invention and the features in it. But provisional means that you are early in discovery, you don't know your final invention and claim. Your final specification will have the actual claims written in a detailed form. That's the 12-month window which we are talking about.
So how that would be patented?
So you need to,
Patented under like a system and methods.
correct, so you need to read them, read the publicly available research papers and what is claimed in the patent. As I said, if this is the research paper and if there is a claim made as a layer to it, so this is known prior art, but this known prior art can be there for 10 years, 20 years, 30 years. Correct? So, but you've added a new invention or a layer of innovation, then your claim will be limited to this green pen on the existing prior art.
Even if the system is already there,
Correct.
and if you are adding some,
Therefore, you need to go on to the IP India website, see what, download the patent and see their claim. I mean, that's where, experts will come in and see what is the difference and what have they claimed over and above what is the prior art. I'm so glad you asked it.
even I write the code and please write the code, it will be similar patent.
So I'll give you two examples. We will come to the software in a bit. If there is anything which is stored in a machine and it is in your power and control, I believe, you believe that I have copied it. You have a code or you have some database or some content which is in your IT infrastructure. If you believe that my colleague who was working with you has taken that and brought to me, proving that in a court by evidence is our nightmare. Because I would not open my server and show it to you freely. You don't know whether that 50 lines, 100 lines, 1000 lines of the code has been picked as is and brought to me. Either I have direct access to your server, then it means your IT infrastructure and firewalls are very bad. Or there is a mole who has left you and come and joined me. Then you need to prove that he had made a copy physically, electronically. You have a system by which you trace that, track that. He would have mailed it to himself and then brought it to here. So those are all circumstantial evidences. The two live examples is that, I mean, these are publicly available, so I won't take names, but you go and see. There was a law firm, a very established law firm in Delhi. One partner quit, left, and set up his own practice with same clients which he onboarded when he was in this law firm. He believed anything which he drafted while he was in this employment, he could take and go. But the law firm filed a complaint against that lawyer. This is a live example. And that lawyer's computer was raided by cyber expert, forensic expert, and they confirmed that the drafts which he made while in this employment were taken by him, which was found to be violation. Right? That is former employee doing it. Now we have a live example which is going, I can't speak about it, which is in Madras High Court about two software companies where we believe that they had a common client and common client said, I am tired of company A, price, charge, feature, whatever. They took that product and went to company B and said, company B, can you make a software with all these features? UI is same, UX is same, pull down menu, hierarchy, the names of the features, all of them are same. And we asked for a court appointed expert to be brought into their servers and seen, and we are in the process of doing that. But it's a practical question. The person is small, the forensic experts can go in easily recover it and come, but it needs the cooperation of the other party to open up and show. But if you take the aid of cyber forensic experts, it's easier. Or at your end, if the person is dumb to mail themselves, you find the mail that is easiest. No, it can't be. So there are 20 words in this screen. I don't own copyright in this word, this word, this word, but in the flow of the words. A plagiarism is when the same thing is taken and pasted on another screen, but not in the independent words or this. I mean, so it is quite subjective. In plagiarism, it has to be cut, copy, paste. If it's reverse engineering, the features, if it is not patented in the software world, right? I'm talking about along with the devices. The codes has to be replicated. If the replication of code is not there, it is not copyright violation. But in a patent world, if you have patented the process or the method, which is combination of software and the device, then you need not have a identical plagiarism. Thank you so much.
And I
Thank
think,
you, everyone.
For a small token of appreciation from our end, this is one of the incubating companies, the
Oh, thank you. Thank you.
It's a new variety of shoe, that's what I'm just giving you. You already have one. So,
Thank you. Thank you.
yeah, so I think KRIA Law we've been working with last 3 years. I think a few months back, and I think April, we done a 3.0.